I thought I would record this to document my trouble with General Motors, Unifor, the Ontario Labor Relations Board, and the Ontario Divisional Court. I was called back to work by General Motors physicians to begin April the 14th, 2023. Um, this is uh, this is my defense here. As you probably know, you're not allowed to record your defense during the actual board tribunal because, well, for obvious reasons, probably because they're so corrupt. The whole bunch of them, well, my union is Unifor, but they all seem to be complicit together. A lot of them are scofflaws, as far as I'm concerned. In my opinion, they are scofflaws. They do what they want, uh, and they cover each other's backs. As you all see, because this is my defense. Now, I do have my records, and they write Canlii, Canlii, and you can see what they put, and there are huge gaps with my defense that they didn't even address, which they should have by the Code of Vavilov. Anyhow, I'm getting a little bit ahead of myself. I was called back to work by the physicians to begin April the 14th, 2023, which only makes sense because according to Vavilov, that adds up because their physicians put me out of work. Their physicians should be able to put me back into work. And that's part of the code. Vavilov says I am at the highest metrics because they wanted to terminate me. I got back to return to work, and HR Sarah Ruddick, I suppose I can say the name because it's all public record on Canlii. If not, then I can do it again, I suppose. Anyhow, it HR notifies me, says, do not step foot on General Motors Canada property because you have a restraining order on you. And by the way, your employment is terminated as of April the 13th, 2023. Well, I'm gobsmacked. What in the world is this about? Well, I knew that General Motors is trying to get rid of legacy employees. That is not a secret. And I am a legacy employee. You can't trust any of these authorities. My union threw me under the bus. 30 plus years at General Motors, don't give a crap. The labor board supposed to protect the worker. They're in league with whatever corruption General Motors and the union. It's like they're in bed together. Anyhow, getting a bit ahead of myself. My local union, 636 Unifor, had the good sense to grievance this and ask for full redress. But then my case is sent to the executive. Well, the executive is led, well, my representative appointed to me was Dino Chiodo. Well, it comes to my knowledge, Dino Chiodo sat the board for Green Shield. Well, Green Shield, they're the ones that communicated against the law according to their own ombudsman, but I'll get to that, which made everything inadmissible, but the court didn't care. Nobody cared except for me. So I says to Dino, I says, how can you possibly represent me without bias when you set the board for Green Shield and they're the ones terminating my employment? By the way, I never worked for Green Shield, ever. 30 plus year employee, clean work record. And the accusation was that one of the doctors that I used, there's how many doctors that were used that we were looking after us over the years. Anyways, one of them apparently did not have a license, and this is the Philippines. Well, then they said that's against your benefits. Oh, well, and did they investigate? I'll get to that as well, because my charge was duty of fair representation. I was not given duty of fair representation. And well, it's obvious I wasn't. And as you'll see, but not obvious to the board, not obvious to the divisional court, not obvious to my union. And it was like a conspiracy against Ron here. Gracious. Well, it goes on. I was in contact with a lot of professionals because I've been after a contingency lawyer for a long time. Well, pardon me. One of the professionals said, did the labor board really say that? And I said, yes, they did. And they said, huh? Well, any layman, it's obvious. He could not represent you without bias. It's a conflict of interest. I said, I know that. Everybody seems to know that. But then the Ontario Labor Board, cha-ching, boilerplate decision, rubber stamp. And they've been reprimanded for that how many times? The Divisional Court knows this. They don't care. They did it again. And they said, we endorse him to represent you. I said, well, wait, I'm at the top of the metrics because according to Vavilov, the greatest punishment a person can have is to have their employment terminated. And I have a right to be heard and a right to be investigated. And everything should be investigated. This is according to the precedents of the labor laws with the Ontario Labor Relations Board. Totally ignored. The Vavilov Code, the Code of Justification, Transparency, and justification. Pardon me, my brain is muddled. This has been going on for like 3-something years, and it gets me. And I told them it was just like that during the board. I said, pardon me, and intelligibility, which refers to step by step, what is your rationale for saying this? Well, I asked Unifor, where is the rationale for you not reclusing this person? He should be recluded. They had none. They didn't care. The board endorsed it. Nobody cared. It's arbitrary. And arbitrary is one of the grounds that you fight duty of fair representation to. Arbitrary meaning something is different that should be, or absent, pardon me, something is absent that should be present, which is not present when decisions are made. Well, this went on and on and on. And, well, the contingency lawyers said, Ron, there's something you don't understand. The Ontario Labor Board, they are experts unto themselves. They have been deemed experts unto themselves. I'm like, huh? There are very few checks and balances. They can say what they want, do what they want. They are considered experts unto themselves. Well, isn't that wonderful? Well, look at the statistics. Less than 1% of every person who's put in, every worker, they're supposed to be defending workers, every worker who is put in for duty of fair representation has won. Less than 1%. And I got thinking, again, I took statistics in university and like, huh? That begs for examination. And then I thought, less than 1%. And then I bet you of that group of less than 1% who won, every one of them had legal representation. Because like I said, cha-ching, the board would just boilerplate everything. And then if you have no lawyer to prompt them to do justice, it's like, get out of here, get out of here, get through the system. But if you have a lawyer, unfortunately, who can afford a lawyer, especially nowadays? Well, I could not afford a lawyer, and I suffered subsequently. And my pension, they want to give me less than $1,000 a month for 30 something years. Part of that was out on disability because their doctors put me out, then their doctors put me back in, and then they, well, you know what they did. I'm trying to fight this. Well, let's go to Green Shield. Because like I said, they weren't even allowed to communicate with General Motors. I contacted Green Shield and I said, what's going on here? And then I get the ombudsman on these emails, and it's all part of the record. That was given to the divisional court. That was given to the labor board. That was given to Unifor. That was given to HR with General Motors. Nobody could reply. And nobody forced anybody to come reply. It's my work. I am out of a livelihood. But nobody, these people who are supposed to be protecting me, these authorities, where are they? You decide. You look at this. You be the judge. Craziness. And they wonder why people are so upset with authorities. Well, the ombudsman said, Green Shield does not pick who is hired and fired, and there should absolutely be no communication to that effect going either way. And this is all in the record, like I said. And I said again to Unifor, okay, it's my right. Nobody from the board stepped up and said, hey, I'm an expert in insurance law, and they are experts unto themselves, but I have a right to have professional input. Nobody, they didn't even bother getting it. They didn't investigate it. Arbitrary treatment again. It's astounding. Oh, okay, let's get to the collective agreement. The collective agreement says you are not allowed to be disciplined for an incident outside of a year of it happening for which you've already been disciplined for, especially for which you've already been disciplined for. And that chapter and verse is part of the record. Well, I was disciplined already, even though this was an untested accusation. Never been before a court of law, never been before a judge or panel or anybody. They just, well, he's a legacy employee, Unifor, under the bus. What do we care? It's, oh, thank you. Did you give me a handshake there? Oh, thank you, a backhander. Yeah. Who knows what happened? Because Unifor loves to Debate behind closed doors, but debate do contractual supposedly deals. Anyways, this happened. You can look it up. It's all in Canlii. Well, what they wrote of it. There are big gaps, and they didn't cover the defense, and they won't. But I have it record. I have records available if anybody. Maybe somebody can even help me. Who knows? I don't know how. And, well, anyways, where's the professional input? Silence. Silence is loud. Nothing. No professional input. No contractual lawyer. What about the investigation? They investigated supposedly this doctor. Where's Unifor's investigation? For example, in this supposed investigation is mentioned a clinic. And this clinic says, they do not know myself nor my family, nor ever have. However, there is more than one receipt registered from them with the embassy in Manila with their letterhead on it. I said this to the Unifor, please explain this. Or what did your investigation come up with to explain this? Crickets. Arbitrary. Grounds, look it up. Grounds for defense for duty of fair representation. Arbitrary treatment. It was absent. There was no investigation. She said something like, well, we consulted the company. Then we went back, talked among ourselves, thought things aren't strong enough. So we'll just go with the company. I said, well, why do I pay union dues? You didn't do an investigation. Oh, there were also affidavits because, of course, the labor board, they said, prima facie, prima facie. Well, prima facie? Oh, you mean for the company to terminate my employment? Oh, no, sir. For you to contest the unfair termination. You're supposed to be defending the worker. And part of their own precedent says prima facie should never, or pardon me, should seldom be even brought forward because their job is to defend the workers. Of course, they had no answer to that again. But then, look at 7 people, affidavits came forward. They found out what was going on. Affidavits in my support, contesting what was happening, what they said was going on about this doctor. Well, Law 101, affidavits establish prima facie. Well, apparently the divisional court judges, I sat before a 3-panel judge. Apparently none of them, maybe they don't have their law training. I don't know. How do you explain that? I can't. And it just, I think it said, oh, we looked at that, there was only 7. I've read of cases where there's been like 1 affidavit and the person goes to jail for how many years? And that, oh, there's, what? Where did you get your licenses? Cracker Jack boxes? I don't understand that. Or at least, where's the rationale? Spell it out like Vavilov says, with transparency, intelligibility, and judicially. Spell it out. Nobody did. No investigation. My representative should have recused himself, but he did not. The ombudsman, that whole investigation should have been inadmissible because it was got by ill-begotten gains. Anything achieved that way is not admissible in court. But they admitted it, and they didn't give any explanation why it was admitted. Go figure. But you won't read this in Canlii because, like I said, they only want you to read what they allow you to read. What else? I even mentioned, look, it's a contract year. If it goes back to the labor board for arbitration, but please give me a lawyer so the board can be prompted to do what is right. But the divisional court couldn't even see themselves to do that. Ridiculous. Because I believe with the lawyer, well, these are obvious transgressions, obviously not of the law, the violating Vavilov left, right, and center, one precedent after another precedent. Anyways, this went on in the contract year. And I said, who was the lawyer consulted whether there's enough information for this to go forward to arbitration? Isn't that at least part of my right? Nothing. No lawyer was consulted. Apparently that's at their discretion. They did have enough money because, oh, we see you were working. I beg your pardon? RSL. Oh, Returned in Services League. Oh, I volunteer with the veterans. Most of them are Korean veterans and veterans of Vietnam. And believe it or not, Falkland Islands is covered as well because not everybody realizes that New Zealand used Falkland Island, Falkland Island, UK, used Kiwi medics. So they're also part of the RSL. And I says, that's not work. I was helping with the drug bank and the medical missions with the children. And I said, General Motors, they said, resign. That's work. That's action. Resign. What could I do? I said, okay, I will resign, but I want a statement from you. If there's some mother or father at my gate banging at the door, give blood, give blood, give blood, because I have a somewhat rare blood type, or my child would die, I want to be able to hold up a placard that says I'm not allowed to because of General Motors. In reality, I'd probably just use General Motors and give the blood. But I wanted this placard. But well, anyways, what happened was they backed down. They said, you must resign, but we will allow you to give blood. Big of them, huh? But that's the example of the ridiculousness and the harassment. And these authorities are there to protect the workers. The boards are considered experts unto themselves with very, very little checks and balances. The contingency lawyers did go on to say, Ron, they are experts unto themselves. However, they are not a law unto themselves. They must follow the precedents. They must follow the laws that are laid out. Well, they don't. If they have a lawyer, well, if the worker has a lawyer, then anyways, get what you can out of this. I don't know what anybody can do to help me. I do have one more case coming up with the human rights because they violated my human rights as well. So hopefully they're more honest than the Labor Board and the Divisional Court of Ontario, the Superior Court. This whole situation, wow. And people get so upset at them, the authorities, and what do? We're looking after you. And their General Motors lawyer even contacted me and taunted me on the phone. You'll have to make a decision this year. because like I said, it's about 3 years. Well, he knows because all my savings are pretty well gone. I'm working online for peanuts. I can't get work. I'm 63 years old. Who wants to hire you? And anyways, I'm doing the best I can. But that he's taunting me, you're gonna have to make a decision this year. Meanwhile, what's he get? Like $500 for every email? And they tried to make a deal with me. And it's like, but the deal was to give me what they already offered me. Huh? They just pushing me to sign off. And that was obvious unfair dismissal. Their own doctors called me back. Anyways, I've ranted and raved. Uh, I'm also went back to I had a backup because I did go to university. If you want to hear that story, let me know. Anyhow, you have a wonderful evening, and I hope your situations are going better than this one. And well, who knows? Maybe something positive will come out of this. At least you'll know what to expect, and get a lawyer if you can, if you're ever before one of these scofflaws, in my opinion, scofflaws, because they don't care about the worker. Unifor, and I've been a member for a long time, they have gone to shite. Then recuse myself. You sat on the board for the and then that labor board. Oh, I endorse him. How? How? Ask any child on the street. Anyways, good night, beautiful people.